Good evening, folks. Did Breonna Taylor grand jury get it right? Did the Attorney General get it right? That's what we're going to discuss today on Black Laws Matter. The Black Laws Matter, as you can tell from the name, sounds kind of tongue in cheek, but it has nothing to do actually with what you think it is. Black's Law is a dictionary. No, it's not a dictionary about epithets against black people. It's actually a legal dictionary. It's called Black's Law Dictionary. That's where we get the name from. Why are we using this name? Because our purpose here is to try to explain the law to people in a way that is easy digestible for the lay person. And that's what we hope to do today when we talk about the Breonna Taylor grand jury events that have sparked a lot of protests all over this country. Last time when I spoke to you on Black Laws Matter, I spoke to you about qualified immunity. And in that particular talk, I discussed qualified immunity, the history of qualified immunity, and I also discussed something I'm going to go back to, which is the opinion of Justice Thomas and Justice Sotomayor on qualified immunity. And that's important in this particular discussion today, and I will get to that shortly. So what we know is the grand jury did not return a true bill for two of the officers. A true bill essentially is when the grand jury indicts somebody. If they don't indict somebody, then they have not returned a true bill. Now in Louisville, in Kentucky, I don't know whether or not that's the same language that's used, but in New York, it's a true bill is when there has been an indictment. However, with respect to one particular officer, that's Officer Hankinson, I believe is his name, the grand jury returned a true bill, finding him to have engaged in wanton endangerment for the lives of others. Now, what was disturbing about that particular finding by the grand jury is that it had nothing to do with Breonna Taylor herself. What the grand jury essentially found is that the officer was not a good shooter. Had he been a better shooter and he had shot Breonna Taylor or he had shot her boyfriend at the time, then he probably would have gotten off just like the other officers. So the question for people who are protesting, and I think the protesting should continue because people need to know, the legislators need to know that the people that have elected them are not happy. So what I think is the protesters are angry about is this justice? Why didn't these other officers get indicted for the crimes that we thought they would have been indicted for, like maybe murder or second-degree murder or manslaughter or something? The answer to that question, unfortunately, is not a pretty one. It's not an answer that a lot of people are going to be happy with. The answer to that question is because it's legal. That's the unfortunate truth and reality of the situation that we are in. I'm going to give you a lot of different examples to show you why that is the case and why until we change the law, we're going to continue to have a lot more Breonna Taylors. After the grand jury's lack of indictment or indictment, depending on which officer you're talking about, we heard from the Attorney General, and then we also heard people tweeting. We heard from the Breonna Taylor attorney, Benjamin Crump. We heard from Kamala Harris. Both of them were dismayed at what the grand jury did. I was shocked that they were dismayed, because in my office, nobody was shocked. But our lack of shock is not because we are cynics. It's not one of those lack of shock because, well, that's what they always do. They never indict a police officer, so what did you expect? No, that's not why we didn't think that the officers were going to be indicted. The reason why we believe the officers were not going to be indicted is because the law is in favor of the officers. Until the laws are changed, things like what happened to Breonna Taylor will continue. So what we are hoping to do is explain to you some of the aspect of the law and encourage people that the best way to deal with these things is to get to your legislators and get them to change the law. Because we are committed to the idea that if you don't understand the law, then you're not going to understand what the world looks like. But the more you understand about the law, the more you are empowered to actually change what the world looks like. And this understanding the law is what is key. So what we know about this particular case is that the officers came to Breonna Taylor's boyfriend's home. The officers claimed that they announced themselves. We know from Breonna Taylor's boyfriend, Mr. Walker, that they did not announce themselves. He thought it was an intruder. He opened fire. They opened fire back. And then we are in the situation that we are in. In Kentucky, it is a open carry, or you can have a gun permit and you can carry guns in um, uh, in Kentucky. But one of the interesting issues in that particular matter is whether or not the officers actually had a no-knock warrant. And that's the thing that I want to focus on here, because I think that's one of the key issues in this particular case. As far as I know, in the United States, there are only two states until recently. Now there's a third, and I'll get to that in a second. There are only two states that don't allow no-knock warrants, meaning if you get a warrant and you go to the person's home, you have to knock and announce yourself. Those two states are Oregon, the bastion of liberal ideas and thought, and the other state, you won't believe it, is Florida, the bastion of conservative thought. Two sort of diametrically opposed states when we think about states. Yet both of these states agree that we should not have no-knock warrants. Now, I want to relate back to when I talked about qualified immunity. When I spoke about qualified immunity, one of the arguments I made as to why qualified immunity needs to be looked at and re-examined is that Justice Thomas, the bastion of conservatism on the Supreme Court, he disagrees with qualified immunity. Justice Sotomayor, the bastion of liberalism on the Supreme Court, disagrees with qualified immunity. You're probably never going to get these two justices to agree on anything for the next 20 years, for however long they live, but they agree on that matter. The reason why I mentioned that is Oregon and Florida, as far as we know from the outside, these are two totally different states, but yet they agree that you should not have no-knock warrants. The third state is Kentucky. After the Breonna Taylor incident, Kentucky now is the no-knock warrant-free state in the sense that you can no longer have no-knock warrants. And why is that important? Because a no-knock warrant basically allows the officers to come to your home, to barge in, break down the door at all sorts of hours in the day. It can be 12 o'clock in the morning, 6 o'clock in the morning, 3 o'clock in the morning, whatever the hour may be. People are going to be startled. If you get rid of the no-knock warrants, it's not going to stop many of the things that we have been seeing around the country. It's definitely not going to stop that. We have instances where you have a knock and announce warrant and people still get attacked by the police, and there's still sort of gunfire between the police and citizens. It's not going to stop it. But just think about it though. What kind of world would you prefer? A world where you have no-knock warrants, police showing up 12 o'clock in the morning, 1, 2, 3 o'clock in the morning, unannounced, of course, don't announce who they are, usually in plain clothes, at least in New York, and many times they are, in plain clothes, they startle people. The person believes there's a burglary. What's the person going to do, especially in a state where you can have guns? They're going to shoot first and ask questions later. And that is actually their legal right in the states where you're allowed to carry states that have what they call the castle doctrine or stand your ground doctrine. In those states, you have the legal right to protect your house, which is what happened in the Breonna Taylor. But then you have to juxtapose that with the fact that the police officers, when they go into a place, no knock or knock, whichever the case might be, they then have the authority to also respond with firepower. But if you have the no knock law, if that's no longer the case, what's going to happen is the police officer can go, they'll announce themselves. If it sounds like there's trouble on the other end, go get backup. Maybe come back another day. There's no need for this. Why this is critical is in a lot of different cases, what we have seen is not that the protests should stop, but also in addition to the protests, we need to sort of maybe be a little bit more laser pointed in what we are going to be asking the legislators in terms of changing the landscape. Again, the more you know about the law, the more empowered you're going to be in terms of trying to change that landscape on what the world looks like. Take example, Eric Garner. Prior to Eric Garner, if I remember correctly, there wasn't even really a chokehold law. After Eric Garner, then you have a chokehold law. People didn't know that. You would think that we don't have any chokehold laws allowing police to use chokeholds after Eric Garner, but that was on the table. Police were allowed to do it. It wasn't until recently, after the George Floyd incident, that now it's no longer on the table. But that's crazy. That's insane that we still have this on the books. So if we're not able to sort of address many of the laws that are allowing police officers to engage in these type of activities, I think we're going to continue to see these types of cases on and on. This is why when the police officers are taken to the grand jury, when we have the decisions like the one we have right now, people are shocked. Yes, it is shocking, but unfortunately, the law permits it. It's an unfortunate situation that we had with Breonna Taylor. We have no amount of money is going to bring her back, even if the cops were indicted and they were convicted. No amount of conviction is going to bring her back. But what we have to do is try to focus on the laws that we can bring about that's going to change that landscape. And knowing that information and petitioning our legislators, depending on what the law is, it doesn't even have to be the no knock. It can be many other different areas that, in which we need to see some kind of change. We have to petition the legislators to see if we can get those particular laws changed. And the reasons that I mentioned in this particular presentation are the reasons that I think impacted the decisions that have led to the grand jury and the decisions that the Attorney General has mentioned. So it's for those reasons that black law actually matters. Once you know the law, you will know how to change the landscape. Thank you very much.